Welcome to the hardcore education group. This is it. I mean, this is the real hardcore group. This is our last speech of the conference. I think it's been a great conference. I sat through most of it. I heard most of the speeches, and it's been a really great experience for us, the ones that put it on, and I think it's been a success, and I hope you feel the same way. I'm going to talk to you about damages, and then I'm going to show you some demonstrative evidence as soon as we get the picture up. I like to start with Aristotle's principles of persuasion. 2,300 years ago, Aristotle, in his discourse on rhetoric, said the first one was maximize your salient points and minimize your weaknesses. And in doing so, how do you know, the real question that we have and that we're wrong about a lot of times is, do you know what your weaknesses are and what your salient points really are? Sometimes we find out too late. We don't find out until we're in the courtroom and here at the same time the jury does as to what our weak points are. So in order to find out what your weak points are and to find out how to really maximize your salient points, what really does resonate, focus groups, 2 words, focus groups. We focus every single case, and we focus damages. We focus damages last because we want to know everything there is to know about our case before we start trying to put together our damages package. I did not say we start working on damages at the end. I said we put together our whole damages package. Our damage proof begins with the first interview with the client. But then we wait until the end, and then we focus our damages, because at that point we know all there is to know, and we can know if we have weaknesses in our liability that's going to affect our damages. So the next thing is to refresh the memory of your audience frequently. This simply means that you have a theme. You have a theme on liability, obviously, but you also have a theme on damages. My theme on damages will often be something they'll vary obviously from case to case, but it may very well be the courage of the plaintiff. This is a plaintiff who's doing the very best they can with what they have left. There are a lot of things that it may be. Your theme may be your client's plan for rehabilitation, how they're executing their own rehabilitation plan, and how much more they could be doing if they had the money to do it. But they're doing same thing, they're doing the best they can with their current resources, but more resources than they can get the kind of help that they need. The next thing is to execute the required level of emotion. Now, when you're talking about damages, you have to be very careful these days. Because of the rhetoric of tort reform, and if you heard my speech on Generation X and Generation Y, which most of our jurors come from those groups today, they're skeptical about us, they're skeptical about our clients. And so you don't want to start your emotional presentations too early. For the most part, you want your emotional presentation to be made during closing arguments. And I like to actually save the real emotional part for the closing portion of the closing argument, because it's the last thing they hear, it's what I leave them with, and it does not give the defense a chance to respond to it. But if you start in, I think the dumbest thing you can do is to start in with an injury case and start talking about the injury first. Just start putting on evidence, or even start talking about it on voir dire first, or start talking about it in opening statement first. I think we have to, these days, make an appeal that makes them understand why it matters what those injuries are. We've heard debriefings on juries where they say, yeah, we heard all that, but so what? I mean, yeah, I heard all that pain and suffering, mental anguish and all that, but they're sitting there thinking, what does that have to do with me? So when you're setting up your damages, I set up damages in this way. In the opening statement, I set up signpost. By that, I explained to them that the damages in this case, after I've discussed liability, I set up signpost in opening statement by saying, the damages that you'll be called upon as the sole judges in this case, you're sole judges of the damages. are physical pain, mental anguish, physical disability, physical disfigurement. Those are the general damages. Now, when you get into the jury room, you're going to be asked to place a dollar amount on physical pain, mental anguish, physical disability, physical disfigurement, and anything else you got. So in order for you to discuss that, you can only do that from the evidence. So I will be bringing you evidence supporting our position, and it's that evidence upon which you will base your judgment. So listen for the evidence of et cetera, et cetera. Now, you've set them up for the anchors. Then when you start examining your nurse, then the anchor is this. You start the question with the nurse. All right, let's turn now to the mental anguish that Mr. Jones suffered while he was in your care in the hospital. Or you talk later, but anytime you get to proof of the physical pain, the physical disability, all right, you got the rehab person on. Let's talk now about the physical disability of Mr. Jones and what type of rehab we're doing to, and so forth. So you set those anchors up, and then you use those guidelines, those signposts, I call them. Use those signposts as you go through your proof so that they'll know that, okay, I got to listen to this part right now because I'm going to be called upon to put a dollar amount on this. So use those signposts and then tie it all together with your emotional appeal at the end. Reference points. There are a couple of points I'd mention on this. We like to set up reference points on damages. You need to prime damages like you need to prime anything else. Pat Maloney, great lawyer from San Antonio, he had a simple, he'd just say, this, ladies and gentlemen, this is a case involving millions and millions of dollars. He never put a precise figure on it. He'd say, this is a case involving millions and millions of dollars, or hundreds of thousands of dollars, regardless, depending on what it was. Most of his were millions and millions of dollars. And so he would do that during voir dire examination. Now, don't get pinned down on voir dire examination on what your damages are, because honestly, you don't know what your damages are. You don't know what your proof is going to be. We all hope we know, we think we know, we pray to God we know what our proof is going to be, but how many times have we been in there? Am I the only one that's ever tried a case where my proof didn't go on exactly the way I wanted it to? You know, I can't remember a case I ever tried where it did. So be careful about making any kind of promises. So keep your position very, very general on damages, and you can talk about the elements of damage, but in terms of the money, I was doing a voir dire, and I said, you know, this case involves millions and millions of dollars. Now, Mr. Jones, if you're called upon, if the evidence supports it, can you return a verdict in millions of dollars? And the defendant objected. He said, we're entitled to know this millions and millions of dollars. We're entitled to know exactly how much Mr. Nations is suing for. So the judge said, Mr. Nations, I said millions and millions of dollars, Your Honor. He said, fine, you may proceed, because that's what we were suing for. We're suing for millions and millions of dollars. But let me tell you, the best way I know, the best thing, if you can get it done, this is the best thing you can do, A, on priming damages, and B, on setting up strikes for cause. And that is if you could get a supplemental juror questionnaire. I've had more luck with this than with anything I've done in terms of getting rid of the tort reform jurors. You ask a question, if you can get your supplemental juror questionnaire, and that's a whole speech unto itself. But if you get a supplemental juror questionnaire, you ask the question something on the order of, if the evidence supports it, can you return a verdict of, and pick a number, $10 million in this case? Okay, if not, why not? And then the tort reformers just can't stand it. They just can't put yes on that. So they'll put no, and then if not, why not, or if no, please explain, and they'll write stuff that will give you the right to strike them because it's predicated by if the evidence supports it. But here's the priming aspect of that. you've primed every juror with the figure of $10 million. So now when you come in and you start putting on your proof and you end up asking for $5 million, it sounds very reasonable. It's a very reasonable request. So, and it can be $2 million. It can be whatever you want it to be. It can be $100,000. It can be $50,000. But it's a multiple of what your actual ask is going to be. So now I taught damages in law school for 25 years, and I've been trying cases for 47 years. And during that time, I've picked up a couple of ideas about how to handle damages. One of the things you have to do, I think these days, is we come in with the conscious mind evidence first. We come in with our voir dire, with our opening statement, and then with our evidence on the things they can see, touch, feel, the actual hard evidence. That's the conscious mind evidence. The physical pain, mental anguish, and so forth, that's more of the unconscious mind evidence. So you want to come in with your strong evidence of things like X-rays. If you're going to, I'm just talking about just your damages proof. You want to prove your liability first, but just in your damages proof, you want to show them things first. Show them things that are real proof instead of. So you start building a body of evidence. Now, here's the thing that I think is the most important thing I've developed over my years of teaching this subject. Evaluate each element of damage separately. In our submissions in Texas, we used to submit physical pain with an amount, mental anguish with an amount, and then everything had to be separate. They kept moving it around, and as we got more and more Republican judges, it became physical pain and mental anguish as one element of damage. Then it became pain and suffering, or pain and anguish. And so here's the most important thing I can tell you, which is that every element of damage should have its own body of proof. And what we do is this. We take the subject of physical pain and we put it up on the board in our war room. And then we put every kind of evidence that we have that bears on physical pain and suffering up on the board. We look at our expert testimony, our lay testimony, our documentary evidence, and our demonstrative evidence, and then anything that we have in discovery, admissions and so forth from the defense, if there's anything there. And we list those on the board. So we develop a full body of proof just on the element of physical pain and suffering, as if it were the only element in the case. When we finish that, we go to the next element, which is mental anguish. And we put mental anguish up on the board. And we say, okay, let's talk about every expert we have that can testify to mental anguish. Let's talk about every page of the medical record that reflects mental anguish. Let's talk about every lay witness we can have who can testify on mental anguish. And then we put what that evidence is up on the board. And then what graphics do we have? What demonstrative evidence do we have? And we go through that with physical pain, mental anguish, physical disability, physical disfigurement, and then we do the same thing with the special damages. Make sure that we got everything, and that way we can sit there at the table and look around the walls. I have 3 walls of chalkboard, and we can look around the room and see our entire body of evidence on damages. Then we go back to the demonstrative evidence part of it and say, okay, what do we have on demonstrative on this? Okay. What can we do to improve that? For the simplest, obviously, is take an X-ray and make it into a positive, that type thing. But how can we improve that evidence? How can we make it more persuasive, more understandable by the jury? Then we look around and we can see the holes in your evidence that way. You can find out where your holes are. And then where you have the holes in the evidence on any element of damage, or liability for that matter, you say, okay, what can we create? What can we create that will help us prove that point? And then we start creating animations, we create timelines, we create whatever we need to fill in those holes. And if you do that, you'll find yourself with a substantial body of evidence. And if you don't, you'll find out by doing that, you find out where your weaknesses are. This is maximize your salient points and minimize your weaknesses. Well, this helps you identify your weaknesses and then figure out how to make them better. Now, I want to talk to you about what I call the segmental approach. This is how we evaluate damages. We break down each element of damage, and we'll walk it through this process. And a lot of these may not apply. Pre-impact terror may not apply to your case. But we don't look at pre-impact terror and say, okay, what are all the elements of damage under pre-impact terror? We look at physical pain and suffering, and we'll say, okay, is there any physical pain and suffering in the pre-impact terror? No, we don't have that. What we have is mental, then we get to the mental anguish, then we've got pre-impact terror. But think about pre-impact terror as this. I represented an attorney whose mother and father were killed as they sat on the freeway in Houston, and they were sitting there in locked-in traffic, and they look up in their rearview mirror, and they see the 18-wheeler bearing down on him, and realize he's not going to be able to stop. And sure enough, he hits them from the rear, and it causes a crash, causes an explosion, causes a burn, and they burn to death. They're trapped in traffic. They're on a bridge. They can't move right. They can't move left. They can't move forward. They're just sitting there realizing that they're about to be hit. The obvious pre-impact terror is the plane that's going to crash. And there was $500,000 awarded in Texas on for pre-impact terror on a plane where they knew they were going to crash, but they lost power, and it took them 7 minutes from the time they lost power until they actually crashed. Those folks had 7 minutes of pre-impact terror. A $500,000 award was upheld just on that one element of damage. The next thing you do is you look at the instant of impact, and I always ask the clients, tell me exactly what happened to you physiologically, what happened to your body at the point of impact, and what physical pain did you experience at the point of impact. Then we go through all the physical pain. Now talk about your mental anguish at the point of impact. What happened to you there? Obviously the mental anguish accompanying pain and so forth. But you build a complete body of evidence just on those by going through this analysis. The next thing is post-impact unassisted. You have times, I had a leg off case where the man's hit by an 18-wheeler, and it's crushed in the front, and he's locked in. His leg it's crushed so thoroughly, the metal is so thoroughly embedded into his leg that they had to come and get the jaws of life and do it. And he's going through all this. They had to use the jaws of life to get him out, to take the door out, and then cut away part of the fender to remove all this stuff, which is still embedded in his leg. Can you imagine that? Well, the post-impact unassisted was he's there and he can't do a thing. What kind of mental anguish, what kind of physical pain are you there when nobody's helping you? There's nobody there to help you, and you're pinned in, and you're just completely blocked in on this, and you're in excruciating pain and horrible mental anguish, and nobody's there to help you. What is it during that period of time? And incidentally, you know who your best witness is on this? Think about it. The truck driver. Because the driver's there and he sees all of this. He's there. And so you ask the driver about it. And he's got two choices. He can either verify your physical pain, verify the horror, verify what's going on there, verify the horrible condition that your plaintiff is in, and verify everything your plaintiff is saying about it, or he can be a complete jerk and say, no, I don't think I didn't notice it. You get some that say, no, I didn't really notice anything all that bad. Didn't seem that bad to me. And that's even better. But then the next thing is the period of peril. There's always that period of peril when you're locked into a car. Let me tell you the classic case. This was such a bad case. I represented a young couple who were on their honeymoon. And they were going along a military road on the border at Texas and Mexico, and there was this big, large machine there that they used to clear the crops, and the guy drives on the shoulder of the road. Well, in the process, they're driving along there, and just as they get there, he swings to make a turn, and when he does, this thing comes across and just severs the top off his car. So here's this young guy. He was a medic in Vietnam. He's got medical experience, and he's got his wife sitting on the front. Well, this happens just at the last instant. He has no time to change it, no time to do anything, and when the car stops, when he finally stops twisting around, he's sitting there and he can't move. He's like that. He literally cannot move anything from the waist up. And he thinks he's quadriplegic. Mental anguish there. He has a real legitimate belief that he's quadriplegic. But he manages to move his fingers, and he finally reaches up and grabs his own shirt. And he manages to pull it around to the point where he can see. He can't twist his neck. And he knows better than to twist his neck. So he pulls his shirt around to the point where he can actually see his wife, who's been decapitated. Mental anguish there, you think? Physical pain, mental anguish. But then there's that period. Now, in addition to that, he smells gas. He can't move. His wife is decapitated. He's totally immobilized. He's on a military road where there's nobody around except the workers in the fields. And he's got to be worried that he's about to burn to death because his car's about to catch on fire. So then people come and they pull up in there to help him. And then you look at what happens during rescue. What they did is they came in, and good Samaritans, but they caused a lot of pain and mental anguish because he had both legs broken and he had clavicular fractures. They reached in, they took his seatbelt off, and they pulled him out, and they hold him under the armpits, and they drag him away because all they're thinking about is the right thing. They smell the gas too, and they're dragging him away from the fire, potential fire. So they're dragging him away by his shoulders. He's got 2 fractured clavicles, he's got fractured ribs, and he's got both legs broken. But they're dragging him away, and of course, unbelievable physical pain, mental anguish involved in that. So even during rescue and that's what happened at the scene. At the scene, he's getting no help whatsoever. He's got unbelievable mental anguish. Then they show up during transportation. You'll find a lot of general damages during transportation. We got the IMEs in who testified as to exactly what happened. His transportation consisted of they brought him. They came. They put the blocks around his head to lock his head in place because, again, he still believes he has quadriplegia because he is totally immobilized. So they immobilize him. They drive him into the hospital there in this small town, and they took one look at him and said, "This is way out of our league." So then they have to drive him 40 miles to another hospital. All this time, the IMEs are trying to do anything they can to help him. They were unbelievably good witnesses. You have them describe the mental anguish, the physical pain that this guy's going through and all the things that he's suffering. And imagine the mental anguish involved in all that. And all the same time, he's still got this image of his decapitated wife in his head. So they finally they took him to the hospital. They got him to the hospital, and they said, this is out of our ballpark. So they had to get a Metajet to fly him to Houston. So they brought him to Houston by Metajet. All that time imagine what's going through this guy's mind, all that time during transportation. Mental anguish? Yeah, I think so. And then the emergency room care. Always look at your emergency room care. And how long did they have to sit there and wait to be before they got any kind of help at all? And a lot of times in the emergency room care, they're twisting and turning your body when you got fractures and things of that nature. But calculate this sometime. Remember that in triage care, when you get to the emergency room, when you wait to see the doctor, they do not give you anything for pain relief, because physical pain is a very important diagnostic tool. So for differential diagnosis, they don't want you have to be hurting so you can tell them where you're hurting. So the hospital does not give you anything for differential diagnosis, for pain relief. So you should actually calculate this. It's very interesting. Calculate from the moment of impact up to the exact moment that they get their first medication or their first shot or their first anything that was designed to relieve their pain. Sometimes you'll find it 16 hours, 12 hours, 14 hours that they're having all this pain. And then how long did it take that to go into effect? And in very serious cases like this, multiple injuries, they won't give and of course this guy went forever because they didn't give him anything until he got into Houston by medevac jet. And then they didn't give it to him when he got there because they're having to know all the things that are hurting him. Now, differential diagnosis. Quite often, in order to diagnose what's wrong with you, they're having to twist and turn your body. They're having to get you, would you lay down on this CAT scan for this CAT scan or this? And now, let me position your leg over this way. Let me move your shoulder this way. You got a fractured clavicle. You got fractured ribs, whatever. There's a lot of pain a lot of times involved in the diagnostic process. Now, always think in these terms too when you're evaluating damages. Major versus minor injuries. We have a tendency, if we have a paraplegia case, for example, we have a tendency to try nothing but a paraplegia case. Don't do that. Here's what we do. I tell my associates, the people I'm working with, whoever it is, eliminate the paraplegia. Now go in and get me an analysis of every injury this person has without regard to the paraplegia. And then you also, if you're representing them while they're in the hospital, if you're there early, you always tell them, okay, they're going to be talking to you about your paraplegia, but be sure and tell the doctors and the nurses about everything else that's hurting you. Be sure and tell them about the fractured clavicle, about the pain associated with the fractured clavicle. And this is no time for stoicism. This is no time to be, the big macho male. Because what happens too, the doctors do the same thing we do. It's in terms of the medical record, they'll put in all about the paraplegia. They won't mention all the other minor things that they're taking care of because the nurses are handling those. And there's just too many things to do. So always look for your minor injuries as well as your major injuries. And the easy way to do that is to take the major injury out and then evaluate it as a standalone case. Treatment and therapy. A lot of times the treatment that you have to undergo is horrible, and the therapy you have to undergo is horrible, and there's a lot of physical pain involved in that. I represented a guy who was, I represented this big macho male construction worker. And he rode a motorcycle to work. And one day he's going home, and he's going down a farm to market road that he went down every day. But all day, the construction crew had been out there working on the road. And they just put a brand new layer of asphalt on that road. And so, and they just The whistle blew at 5 o'clock, and they left, and they just forgot to put that damn sign up that said, switch over. They did nothing. It was just there. So he goes flying off on a motorcycle into freshly poured asphalt. Yeah, think about it. Okay, he does a flip in the air. He's a big guy. He does a flip in the air, and he hits on his back, and he skids along on his back, and then the bike is flipping end over end, and he stops, and then the bike lands on top of him and fractures his leg, and then falls over on him. To make it even worse, the gas cap is off, and the gas tank is leaking. And then, to make it even worse, the woman behind him did the same thing. She just drove right on into it, and he is literally looking up at the end of the thing. The woman thought she'd killed him, because at the end of it, he's looking up at the undercarriage of her vehicle. She was that close to him. She didn't hit him, but she was that close to him. Okay, so this guy comes to the hospital, and they had to do this little treatment for him, and it was not something that I even noticed. Carolyn St. Clair, who's RN JD, who's been with me for 30 years now. Carolyn's going through the medical records, and I'm saying, okay, go through here and find me everywhere where there's physical pain, mental anguish proof. So she comes back and she said, this ought to be interesting. We've got to talk to this nurse. And the whole entry was beta, B-E-T-A. That's all it said. And then the next day, beta. She said, this ought to be good. And this is why you get help from professionals. Said, we need to talk to this nurse. So we go down and talk to the nurse, and what it was a betadine scrub. And a betadine scrub consisted of, this guy had asphalt completely embedded into his back and into his buttocks. I mean, deeply embedded in it, okay? And he had all kinds of other injuries too. But every day she would have to go in, and so we got her to testify. She had to go in and do a betadine scrub, and she'd take the betadine, and she would put it all over his body, which was that was painful in and of itself. But then she would take tweezers, and she would dig down into his body to remove the asphalt. And so we asked her, said, did you do it all at one time? I see what you had to, why did you have to do this over like a 5-day period? And she said, because it was too much pain to tolerate. I wouldn't put him through that much pain to tolerate that all at one time, so we had to do little segments of it. And how did you do it? She said, well, we'd have him put a towel in his mouth, and when we did this, so that his screams wouldn't disturb the other patients. And this was a guy who thought John Wayne was a sissy. And we said, and what was his response as you did this? She said, he cried like a baby, okay? And he hated me for proving that, so that's just a simple thing. I mean, when I say go through your medical records and find these things, that was the word beta. That beta was a hell of a lot of money in physical pain and mental anguish. All right, then between therapies, he's laying there for 24 hours a day, figuring 24, wait until this starts again tomorrow. A lot of mental anguish in that. Patient decision making. I'll hit this real quick, and I'll let you out of here shortly. Patient decision making. I had an 18-wheeler driver that I represented, and he was involved in an accident with another 18-wheeler, and they had told him that, okay, you've got until tomorrow morning to decide whether we should amputate your leg, because you've got the possibility of gangrene. We may be able to save some of this. We may be able to save it. We put your risk at 50-50. Now, you have a nice peaceful night there? You have to make a decision as to whether or not you're going to have your leg amputated the next day. Little mental anguish involved in that? I think so. Informed consent. Just the informed consent alone. You're going to be given this, you're going under general anesthesia, you're going to be done this and this and this. You may get AIDS, you may have blood transfusion. There's a risk of AIDS with blood transfusions. You may, my dad had surgery, and my mother called me and she said, you got to come down here and talk to him. He won't sign this informed consent thing. And I said, okay. I went down and he said, they say I can get AIDS. I'd rather die. I'd rather not have the surgery than to get AIDS. And I said, oh, okay, that's just a routine. So I had to talk him into signing the thing. But it also says you can get brain damage, you can get this and this and that. All those contraindications that they put in there to cover their ass on malpractice cases, those are great things. So they go over all that, and then they sign it, they leave you and say, okay, have a nice night, and I'll see you tomorrow. That's mental anguish. The next thing is preoperative testing. A lot of times your preoperative testing is worse than the exam, the myelograms they do, things of that nature. Look at the surgery. All surgeries are not done these days under general anesthesia. A lot of times people are doing areas where the surgery is just blocked off and they're wide awake when the surgery is being done. Just check into that. Don't just assume they were under general anesthesia. You know, what's that? I smell burning. Oh, that's my skin. But they're very awake when a lot of this is going on. The next is postoperative recovery. There's a lot of pain, mental anguish, and so forth involved in that. You just need to go through it on a case-by-case basis. Then there's prosthetic frustration. Go over to the rehab people. Go over, if your client's in rehab, if you get a client and you get them when they're still in rehab, go in there and go through that rehab with them. Experience it with them. Watch them. Videotape them. It's so frustrating. Somebody who's lost a leg, for example, trying to learn to walk again, trying to learn to stand alone again, that sort of thing. The rehabilitation process. Your rehab expert on your physical therapy and your vocational rehabilitation, they can be great experts for you on physical pain, mental anguish, and they're also your physical disability experts, and they can make great witnesses for you in that regard. The next thing is when you return home. What are the duties? The wife or the spouse or the husband testifies that these are the things I used to do before. And of course, a disability are those things that you could do before that you can no longer do. So what are the duties at home? What did he used to do at home that he can no longer do, that you now have to pay somebody else to do, or that you have to do yourself or someone else has to do for him? There are a lot of those. Recreational disabilities. What were the things you used to do? This is loss of enjoyment of life, actually. What are the things you used to do for pleasure that you can no longer do? Because of the disabilities. And then you talk to the employer. What were the problems that you had when you returned to the workplace? What could you do on the job before that you can no longer do on the job now, which bears on your wage earning capacity? You can be making more money now than you made before you were injured and still have damage to wage earning capacity. Don't ever miss that point. Wage earning capacity doesn't mean you're making less money. It means that you're making less money than you would have been capable of making had you not been injured. So don't just look at wage loss, look at damage to wage earning capacity. And then future damages. I always have, you look at your life care planners, you look at your current life expectancy to see how long your future damages are likely to last if it's a permanent injury. And then I always told my students, I said, I want you to, my associates that worked with me, and I taught my students too, always plead future damages. If you don't recover them, no harm, no foul. But if you haven't pled them and you have them, you may run into a problem on trying to get a trial amendment. So plead your future damages and don't overlook that. So one day we had a law student, former law student of mine clerking for us, and my associate came in and said, I think he really took you to heart on this, because he said, you need to read this. And it was a wrongful death case, and it said, decedent has experienced funeral expenses in the past and in all likelihood will experience funeral expenses for an indefinite period of time in the future. And so I called him in and I said, well, what are we dealing with here, the eternal flame? And he said, no, the suit was rented. So don't miss out on the possibility of future damages. I've just told you absolutely everything I know about damages. I'm stopping exactly 8 minutes early, so you can get out of here. I hope that the summit has been a success for you. It's certainly been a success for those of us who are putting it on, and we look forward. We hope you'll come back next year and bring your associates and tell your friends about it. And everybody travel safely, and thanks very much. Thanks. See you, man.